In this video, we're going to be going over Chapter 12 in the book, dealing with employee management issues. Some of the things we'll get into are things like labor unions, some of the tactics that are actually used in labor management conflicts, and some of the controversial issues that companies deal with today. Now, a union is basically a group of folks who get together and they have an organization that represents them on various issues. Things like contract negotiations, what people are going to be paid, what the working conditions are going to be, things like that. You can thank labor unions for minimum wage laws, overtime rules. You work over 40 hours, you get time and a half. Workers' compensation, in other words, if you're hurt on the job, then you can get a portion of your salary paid while you recover. Severance pay, child labor laws. Because of the unions, child labor laws have been outlawed. And so there's all kinds of things that we can thank unions for over time. Now, unions have actually decreased because of the manufacturing here in the United States decreasing. The number of manufacturers and the people who are working in it has been decreasing, and things going overseas. So unions have actually been decreasing, except for public sector unions. So you're talking about unions for government, teachers, things like this. The largest union here in the United States is the NEA, the National Education Association, which is all teachers. You can see where union membership in the public sector is about 34% of the people, whereas in the private sector it's less than 7%. Now, unions were initially started back in the 18th century, where it was actually crafts. So, for example, you're talking about, shoemakers, you're talking about blacksmiths, things like that. And they were deciding to get together to provide some protection for the people who were working within those crafts. And you had various labor organizations getting started. You had the Knights of Labor, and you had the AFL, the American Federation of Labor, that was started back in the late 1800s. And what they were doing was really focusing in on craft unions. Craft unions are things like plumbers, people who are working in a particular craft. CIO, the Congress of Industrial Organizations, was started to represent industrial unions. So, for example, things like automotive. What they were doing was pulling together industries, people who had different jobs but within a particular industry. Now, the AFL and the CIO actually merged back in 1955. And so you have the AFL-CIO today representing about 55 unions and a bunch of union members, as a part of that. There were various acts and laws that were put into place that allowed unions. Before unions actually were legalized back in the 1930s, unions were broken up by courts thinking or saying that they were basically trusts. If you remember Teddy Roosevelt and his trust busting and things like that back in the late 1800s, unions were considered trusts at that point in time and considered a restraint of trade, and they were broken up quite a bit. Well, it really started to come about in the 1930s with the Norris-LaGuardia Act, basically saying, okay, yellow dog contracts, where you have to sign a contract saying that you will not join a union if you can go to work there. That was illegal. The big one that came about that allowed unions and gave unions credence was the Wagner Act of 1935. Basically said, okay, employees do have the right to form and join unions. All right, they can do that, and they can collectively bargain, they can strike, they can provide boycotts and things like this. And it also set up what's called the National Labor Relations Board, the NLRB, to oversee all of the things that go on as far as labor practices are concerned. The Fair Standards Labor Act of 1938 brought about that whole idea of the minimum wage. And the first minimum wage was set at 25 cents an hour. Big money, right? Now, in 1947, you had the Taft-Hartley Act. The Taft-Hartley Act basically gave some power back to the companies and the management. It said that you could not have compulsory union membership. And it outlawed secondary boycotts, and we'll talk about that here in a bit, and closed shops. Then you had the Landrum-Griffin Act of 1959, which basically gave more power back to the union members. In this case, what it did was it said that the union members could vote a union in, and they could vote a union out if they wanted to. The NLRB will then manage and provide guidelines for any kind of unionization. So if like about 30% of a company's members, employees, sign cards saying, yes, we would like to see a union in here, the NLRB will then come in and they will run an election. If a majority of people who are voting vote to say, yes, we want to have a union represent us, then that union is certified. Certification is where unions will say, okay, we do not want this particular union to represent us anymore. And it takes an election, majority of people vote for decertification, the union no longer is representing those people. Now, why do people join unions? I mean, first of all, I've always heard that a company gets a union when it deserves one. In other words, you have poor employee relations, you have a poor organizational climate or work conditions. A company gets a union when they deserve it. That's why it's so important. If you as a management team do not want a union in your organization, you treat people right, you pay them a good wage. Now, there are different forms of union agreements. Now, the closed shop is illegal now, okay? The Taft-Hartley Act said, okay, you can't do this anymore. A union shop is an employee can be hired who is not a member of the union. However, they have to join the union after a certain length of time if they want to keep their job. An agency shop is basically where you can be hired there and you do not have to join the union. However, you have to pay the union fees. And the reason is for that, the union is saying that they are representing you still as far as contract negotiations and things like that. An open shop is where you can go to work for an organization and you do not have to join the union if you don't want to, and you don't have to pay the union fees. That goes along with what's called right to work laws. Based on what the states decide, states can decide whether they are a right to work state or not. If you are a right to work state, you can go to work someplace. You do not have to join a union or pay the fees. Kansas is a right to work state. If there is a disagreement between labor and management, what happens is shop stewards will represent the employees and will file a grievance. Basically, they're saying, okay, the company or the management is not abiding by the contract that we have in place. And what they do is they start to work that out. Whenever the contracts come up for negotiation, in other words, contracts are expiring, things like that, or if there's a grievance, there are different ways of getting through it. Now, first of all, you have to remember, particularly with contracts, there's going to be a bargaining zone. Management is going to come in low. Unions are going to come in high as far as what they want the pay to be, as far as what they want the working conditions to be. And between there is that bargaining zone. Mediation is where you have somebody who comes in, and what they do is they try to get the two parties to come to an agreement, come to a consensus as far as resolving the dispute or the contract. If you can't come up with any other solution, then arbitration may be the way that you have to go. Arbitration is basically saying we're going to bring in like a judge, and the judge or the arbitrator is going to hear both sides and is going to say, okay, here's what it's going to be, and both sides have to agree, have to abide by it. What unions do whenever there's any kind of conflict is they can strike, boycott, slow down their work, and picket. So these are the various tactics that they can use. The strike is basically where the union members say, we're not going to work. They shut down the machines, they walk off the job. The whole idea behind it is to hurt the company to the point where the company will bend to their needs or bend to their wants and go along with what it is that the union wants. A boycott, a primary boycott, is where the union says, okay, we're going on strike. We're not going to buy any of the company's products, and we don't want their customers to buy any of their products. A secondary boycott is where maybe the auto workers are going on strike, and the pipe fitters will then say, okay, we want everybody else to boycott the auto workers' cars that are being made. That's secondary boycott. That is illegal based on the Taft-Hartley Act. What management can do whenever there's one of these conflicts is a lockout. In other words, okay, we're just going to close the doors. You don't want to come into work? That's fine. You're not going to get to work. They could have an injunction, which basically says, is a court order that says, okay, you must do this or you must not do that. Many times, management will bring in strikebreakers. In other words, they'll bring in people who come in and actually do the work while the union members are on strike. If unions are going to grow, now unions have, the size of unions, the membership of unions has decreased over the years. During the 50s, they were at their highest rate. Today, it's much, much lower. If they're going to grow, they have to go more towards the white-collar type of jobs. Right now, they're looking more towards healthcare, nurses, things like that, and information technology, programmers, those sorts of folks. You can see that union membership is centralized in various areas. So, for example, you have more unions up in here in the upper Midwest, out in the West, and in the Northeast. It's lowest here in the South, and here in the Midwest. One of the issues that a lot of unions and workers have is executive compensation. They're basically saying, hey, the execs are making too much money. There is so much that they're making, and our members are not making nearly as much. One of the issues that a lot of people don't understand is, for example, here it says that the average CEO compensation is over $10 million. That is not all in cash. They might be receiving $3 million in cash, the rest of that in stock options. And so a misnomer that a lot of people have when it comes to executive compensation is where that money is actually coming from. Now, they're still making a lot of money. The issue is how much, and then also the board of directors are allowing it. So if you have a problem with what it is that people are making, you have to talk with the board of directors, which the owners, the stockholders, are actually voting. Now, some people are saying that CEO shouldn't make any more than 20 times. Okay, they're making more than that. All right, again, that's up to the board of directors. The Dodd-Frank Act was intended to help with some of these compensation issues and compensation decisions. Hasn't really helped that much. There is that issue as far as pay equity between men and women. There's a lot out there that's saying women are basically making 79 cents for every dollar that a man makes. There's a lot of competing research that's going on with that, some saying it's worse, some saying it's more. That is something that you may want to look into for yourself. Now, sexual harassment. This is a real issue between employee and management issues. Sexual harassment, unwanted sexual advances, asking for favors, or creating a hostile work environment. Folks, let me put it to you this way. Don't do it. It has no place in business today. You don't have to do something where you're making comments to somebody else. You don't have to do something where you are setting it up so it's a quid pro quo. In other words, a this for that. You do this for me, I'll do this for you. That is illegal. It can get you in a lot of trouble. As a manager, if you are charged with that, if you are sued for a quid pro quo or a hostile work environment, sexual harassment suit, You can be sued personally, not just the company. The company can be sued also. You can be sued personally for anything that goes along with that. Childcare is another employee management issue. A lot of women are working today. And one of the things that happens is women tend to be the primary care, providing the primary care for children. So a lot of absences are costing billions of dollars because of childcare issues. So one of the things that a lot of companies are doing is setting up benefits to help with that. Some companies will actually set up on-site childcare centers. The thing is, that can be very expensive as far as insurance and things like that are concerned. Sometimes what they'll do is provide discounts with various childcare providers. So these are some things that companies are doing to help alleviate that issue of childcare issues between employees and management. We're also living longer, and more people are taking care of elderly parents. So elder care is becoming a big issue with companies today also. There's also a lot of drug abuse and drug testing issues that are going on, particularly with the legalization of marijuana in various states. More and more people are starting to test positive for drugs and alcohol. Drug and alcohol abuse can be a real issue with companies. You're not only talking about safety, you're also talking about lost efficiencies and things like this because people may be out. Over 60% of major companies drug test new employees. Now, some people say, hey, it's legal in this area here. All right, let's say you're in Colorado. It's legal in Colorado, so what if I smoked marijuana over the weekend? Well, the problem is a company may say, if you test positive, you cannot be hired, or you could be fired if you're testing positive. They still have that right to do that. And there's a real issue because these states are allowing use of marijuana. It is still illegal at a federal level. So there's some real issues that are going along with this. You also have the issue of violence and bullying in the workplace. There is quite a bit of violence that has gone on, particularly over the last 10 years or so, where people have been hurt or killed because of violence in the workplace. Bullying is 4 times more common than sexual harassment, which is basically any kind of psychological or physical abuse as far as what people are doing to someone else. So these are some of the key concepts from this chapter. If you have questions, give me a shout.